Hey gun people! So I've been sent this a few times. Steve Lehto covered a case about can cops force you to unlock your phone? And if you want to watch Steve's video, I mean, you can go to his channel and look at it. I listened to it. I agree with most of what he said. Just from a cop perspective, I think he missed a couple of things. I'm not saying I'm smarter than him. I'm not saying he's wrong. I'm just telling you, I'm going to give you a different perspective. If you go listen to him, he gives you his legal lawyer. The one thing that I absolutely agree with him is at the end of his video, he says, why couldn't the cops get a warrant? Cops are told to get warrants all the time. When in doubt, get a warrant. If you get a warrant, you can't lose. Warrants are not that hard to get. As a matter of fact, they're too damn easy to get. Cops don't want to put the time in to do it. And in my opinion, if you could have got a warrant and you didn't, you lose it. And that's the way it used to be. The courts, that's the first question. Give me the exigency. Give me how things are going to be destroyed. Give me a reason to justify for you to say I didn't have time. In this case, the parolee was in handcuffs. They had him in custody and they had his phone in custody. There was no exigency. Therefore, they should have got a warrant. Now, the Ninth Circuit, I call them Ninth Circus instead of the Ninth Circuit, they're one of the most overturned courts, and sometimes they come up with some pretty good stuff. So I'm going to go over the actual case here on reason.com, and they're the one that did the article. And I'm just going to read the article and kind of explain it to you. If you listen to Lehto first, you'll probably have a better concept on what I'm saying. Okay, so we keep more personal data on iPhone, Android phones. I think your phone is an extension of your home or your bank account or any container locked and secured. And even in most cases in court law and findings where cops, I can search without a warrant things that are a danger to me or where a weapon can be easily accessed. But if something is locked, it is of no danger to me. Therefore, the exigency to circumvent the Fourth Amendment to unlawful search and seizure is not breached, and I need to get a warrant. Phones, I think, is a locked container, and it's not a danger to you, especially if you're handcuffed and don't have access to it, or if it's in police or government custody. So that's just something for a frame of reference. This week, the federal court decided police officers can make you unlock your phone in proof. I'm not sure I agree with that. I haven't read the case. I haven't even read this whole article. But from listening to Lehto, I'm not sure that's the ruling. I mean, they did say that, but I don't think that's going to hold the test. The thing that changes this whole case that I think Steve missed was the guy was on parole. And when you're on parole, you don't have right to privacy. You sign away your right to privacy to government. One of the parole conditions for almost all parolees, unless it's changed, is you must notify police officers that you're on parole, and any police officer at any time can search you at any place, can enter your home at any time and search your home. If you're on parole and I stop you, I can go, get in the car, we're going to your house, and I'm searching your house. I don't need a warrant. I don't need consent. I don't even need probable cause. He's on parole. He has no expectation of privacy. I'm the government. I can go search his house. So that's where I'm leading that the court kind of ruled in the cop's favor here is because he's on parole. But maybe not. Again, I'd have to read the whole case. Okay, Jemery Plains was pulled over by two CHP. Ooh, those guys are good. Freaking ticket writing little punk. Anyway, officers for tinted windows, a bullshit traffic stop. Payne admitted that he was on parole. Okay, that changes everything. When you're on parole, that means I can search you, I can search your car, I can search your phone, I can search anything. Even locked places, you have to unlock. I don't need a warrant. That changes my whole view of this case. But anyway, after finding Payne's cell phone in the car, officers unlocked it forcibly by pressing his thumb against it when he was handcuffed. Now, the cop said that he reluctantly unlocked his phone. There's no way that's going to hold up in court. No way, I mean, in this day and age, anything can happen. But normally, a reasonable judge is going to say, if a guy isn't handcuffed, unless you show me audio that you said, do you mind unlocking your phone? And the guy said, sure, let me move my thumb to the side and unlock it for you. Unless you have audio of that, no court is going to believe that a guy voluntarily unlocks his cell phone when he's handcuffed in the back of a police car. But the cop lied and said he did it, which is bullshit. Is the cop going to be charged for lying on an official document? Is he going to be charged for lying under perjury if he testified? Of course not, because we don't hold cops accountable, and we've got this bullshit propaganda of back the blue no matter what they do, and it's bullshit. But here we go. Reluctantly unlocked his phone. The government later accepted in court that the defendant's number was compelled. So when it says the government accepted, that means that the DA was arguing for the cop, and then the DA went, there's no way this is going to fly, so we'll go ahead and accept that we made him do it, but we still think we're good. And I kind of agree with them, not knowing the facts of the case, just on my experience dealing with parolees. Okay, the officer searched through Payne's camera roll, found video of the same day, which appeared to show several bags of blue pills suspected to be fentanyl. After checking the phone's map and finding that now I agree here that this is good police work. To me, this is good investigative police work. The cops could have been lazy like most CHP officers. I'm thinking these cops were probably either drug or task force, and they were targeting people or cars that fit the drug trafficking profile. But Rick, cops can't profile. That's bullshit. Cops profile all the time. But anyway, so, and that's why they stopped him. That's why they honed in. And that's why they used these investigative techniques, which most street cops would not do. They would take the easy way, write him a ticket, and move on. Okay, so they saw several bags of blue pills, suspected it was fentanyl. After checking the phone's map, finding the suspect's home address, the officers drove him, used Payne's keys, and entered and searched his residence and found and seized over 800 pills. Here's where we get into the technical stuff. Maybe I should put my little picture up here so when I'm talking, you hang on, let me see if I can change that. Okay, here I am. So now it's got me in the recording so you can see me. So when they go to his house and search his house and find 800 pills, the problem is government has to show that we obtained this 800 pills of evidence against this guy legally. And the only way you can seize it legally is if you're in a spot you're allowed to be, you have a warrant, or you have exigency. In this case, I would say that the fact that he's on parole and he's on searchable parole, that the exigency was the reason they were allowed to get in there. And I think the pills should be able to be used against him. In this case, he's on parole. He's already committed crimes. He's out. He should be in prison. At a minimum, this is what's called a parole violation. When you get out on parole, part of your contract with the search and seizure, and you're allowed to be searched and patted down and searched at any time, anywhere, any place. The other part of that is if you violate any law or commit any crimes, your parole can be revoked and you will come back to prison and serve the rest of your time. So let's say I get 10 years and they parole me in 4 years and say, we're going to parole you for the last 6 years. You've been doing good and we're just going to keep you on supervised parole. And if you go out there and don't commit any crimes, you get to serve your 6 years by just checking in and being harassed by cops and not having any rights, etc. But if you violate those terms, we're going to put you back in prison. You're going to finish your 6-year term. And I think that's what they might have done. I'm not sure, again, without reading the case. They could have took a new charge and charged him with possession with intent to distribute, sales, got him a new charge, got him a new prison sentence, and got him more time. The problem with that and how DAs kind of figure out if they're going to charge this guy with a new crime or just violate him is, let's say he owed 6 years. And by violating him, he goes back in for the 6 years. He's not eligible for parole and he does the 6 years. That's more time than if we go through a trial, he gets an defense attorney, we go through suppression hearings, we try to get a conviction, we run it by a jury may or may not convict. And even if we get a conviction, we're probably going to give the guy maybe 7 years. He's going to get off in 2 years with good behavior. So looking at it, it's easier to just violate him for his parole violation and send him back for a 6-year term. So that's how, in the DA's office, how these things are kind of calculated on how we're going to do this. Are we going to charge him with a new crime and jump through the hurdles and do all this? Or are we just going to violate him and take the easy way and he gets more time? So, and again, I'm kind of okay with that process. Some people may not. But anyway, so they go inside his hearse. They find and seize 800 pills. Payne was indicted for possession with intent. Okay, so again, I didn't know this. So it looks like they charged him with a new crime. So if we charge him with a new crime, now we have all these hurdles. Were you where you're supposed to be? Were you allowed to be there? Was there an exigency? Did you have a search warrant? Was the evidence you seized legally? And that's where we get into the problem, and I think that's where we end up with this ruling. In a motion to suppress means that the defense goes, hey, we want those pills tossed out and suppressed because we think the cops violated his rights and didn't get it legally. And that's what a motion to suppress is. And then you have a hearing and you go in for a judge, and I've gone through these where I get evidence and they go, hey, we want to suppress this. They bring me in, blah, blah, blah. And I've only had evidence suppressed one time on me. I've told the case where the guy had some, I think some drugs and a stolen stereo where he cut the wires in the back, and I stopped him for a traffic stop, and the judge was like, well, you admitted that you weren't going to give him a ticket, because I didn't give a lot of tickets. And when they asked me, when you pulled him over, are you going to give him a ticket? And I went, no, I was going to let him go. But when I saw 3 or 4 stereos with cut wires in the back, I was like, this guy may be engaged in other crimes, and he's stealing stereos. And the defense was like, well, you didn't know he actually stole those, right? He could just be a stereo repairman. I go, well, most stereo repairmen don't cut the wires like they're ripped out of a car very quickly. And the objection, Your Honor, he's not a repair specialist or whatever, you know. But anyway, because he does that, I end up, I think, getting consent, or I pull him out of the car, I search the car, and I find drugs. And they're trying to get the drugs suppressed. And the judge ended up suppressing, I think, the drugs I found and the stereo. And the DA was sleeping. I had a cheesy DA. There's no way that should have been suppressed. Had nothing to do with whether or not I was going to give him a ticket. But the judge said, because I said I wasn't going to give him a ticket, therefore the stop was really over, even though I saw another crime and got independent, articulable suspicion that a crime was being committed, about to appear, or had been committed. So the judge kind of tossed it out, and the DA was kind of sleeping and didn't object and do his shit. So afterwards, the DA came up and goes, man, I'm really sorry. The judge shouldn't have thrown this out. He's very, liberal. He goes, I'm going to appeal it. Don't worry about it. We'll get it reinstated. And I go, dude, I don't give a fuck if it's reinstated or not. If you want to get it reinstated. He goes, oh, if you don't care, then I won't do it. And I go, I don't care. Shit, the guy I did my job. If you guys don't want to convict him or don't want to go through the trouble, I don't give a shit. So he didn't file the appeal. But I think we would have won on appeal had he challenged it. But that was the only case where I had evidence suppressed, because I did shit usually by the book. I say usually just in case there's one time that maybe I slept over. But in my mind, I always did shit by the book. In a motion to suppress, Payne's attorney argued that by forcing him to unlock his phone, it was compelled testimony communication, violating his 4th of unreasonable search and seizure of the 5th Amendment. So the 4th says unreasonable search and seizure. The 5th is your right to provide self-incrimination. As the government, I cannot compel you to provide evidence against you. I can't say, you need to tell me you did it, or I'm going to beat the shit out of you. And, okay, man, don't beat me. I did it. That's compelled testimony that violates my 5th Amendment to remain silent, and I don't have to cooperate with government, which everybody ought to know, and we shouldn't cooperate with government. You shouldn't talk to the police. But I digress. They're saying he was compelled to put his thumb on a phone, which gave evidence against him. Now, this is where, as you as a citizen and get caught up in this with a cop, you need to be able to say, look, I don't want to give you access to my phone. I don't consent to you having access to my phone, and I think you need to get a warrant. And you need to make the cop compel you to do it, either by saying, if you don't do it, I'm taking you to jail. If you don't do it, I'm going to grab your hand and forcibly make you do it. And then you need to say, under threat of being arrested or physically abused being against me, I'm going to give you my thumbprint, but it's under protest and it's not voluntary. And then you give them the thumbprint to avoid that other shit. Or you can go, fuck you, do what you got to do. I ain't giving you my thumbprint. But it's up to you. But I think what this parolee did, because most parolees are kind of like, fuck, I'm fucked, man. They're going to do what they're going to do anything. I'll just keep my mouth shut because that's what my attorney told me to do. And so when they said, give me your thumb, he didn't resist because he didn't want to get a resisting charge, and he let him take it. It was absolutely compelled. Cop took it should not have had it. However, because he's on parole and he has no expectation of privacy, and he signed away his rights to privacy, and he signed away his permission by getting out, that government could search him at any time, in any place, at any time, for any reason, without a warrant, I think he loses his Fourth Amendment protection on this. Even though the provisions of his parole required him to surrender any electronic device, see, I didn't even know that was a specific condition. They put that in his condition. He's required to surrender electronic devices and passcodes. So to me, it's a no-brainer. The cops had right to his phone. Failure to comply could result in arrest pending further investigation. The confiscation of the device pending investigation, not the use of force to make him open the phone. So I think they were arguing that he still had a choice. He could have said no and said, arrest me. And the cops took away that choice and forcibly took his thumb and took his thing. I would probably agree with that. He did have a choice, but I don't think he had a right to privacy. So I would still think the evidence seized was good. Again, we get into fruits of poisonous tree. The fruits of the poisonous tree is if cops do something wrong at the beginning, anything they find later is no good. So what we're trying to do here, what the court's trying to do, or the defense attorney's trying to do, is say the cops planted a bad seed when they forced his thumb. Therefore, they would have never and should have never seen the picture of the drugs. Therefore, if they didn't see the picture, they would have never searched his house, and therefore, they wouldn't have found the drugs. So everything should be wiped away under fruits of the poisonous tree doctrine. That's where I think they're going. The district court denied the motion to suppress. So the district court said, no, we ain't suppressing it. We think it's good. Payne pled guilty. In November, he was sentenced to 12 years. Okay, remember I told you at the beginning, if it's less time, they'll blow it off? They were going to get more time by charging him with a new crime, so that's why they charged him. So he got 12 years. Payne had only served 3 years for his crime in which he was parole on, which are not telling. Oh, assault with a deadly weapon on a peace officer. Payne appealed the denial of the motion to suppress. So he's appealing, saying the court got it wrong. They should have suppressed it. And they appealed it. Opinion authored by Tallman of the U.S. Court of Appeals and the Ninth Circuit ruled against Payne. Searches, instant arrest are accepted part of the Fourth Amendment. I don't agree with that. That's the law. I think it's abuse and it's bullshit. I think a search for a weapon is approved on the Fourth Amendment. If I arrest you, I should be able to search you for a weapon. But I don't think you give up your right to, I shouldn't be able to search your phone because that can't hurt me. And I shouldn't be able to search your entire car because you're out of the car and I have you handcuffed. You no longer have access to that. But the courts have morphed that into, oh no, if you arrest you, I can go back and search your whole car. I think that's bullshit. Car is just like your home or your castle. You have a right to privacy. That's what the founders wanted. They didn't want government being tyrannical and searching shit. But again, they have watered down the Constitution now with exigency and all this other shit. They're giving cops all this power, and then we still have idiots running around who thinks cops don't have enough power and we should back the blue when they're out there killing everybody. But I digress. A significant diminished expectation of privacy, even under those conditions of his parole status, did not require him to provide a biometric identifier that was sufficient to support throwing. The Supreme Court said cops can search, so they ruled against Payne, not for him. And now his sentence is upheld, but by upholding his sentence, they upholded that cops are allowed to force a fingerprint. And I don't necessarily agree with that, because if you take the parole aspect out of this case, I don't think they rule that way. If this case is reviewed, I would hope the higher court would say, Ninth Circuit's got it wrong, because they're going to look at it and go, the Ninth Circuit would be right if he's on parole. We agree with him. But we can't make this standard procedure now for all law by upholding it or by refusing to hear it, because now cops can force you to open your phone with this. I don't think that's true, and I think it's going to be challenged, and I think other cops are going to try this, and it's going to be overturned. But we'll see. Tallman went one step further against his Fifth Amendment analysis, self-incrimination, and he was compelled to, with his thumb, to unlock his phone, which had already been identified by officers, required no cognitive exertion, placing it firmly in the same category as a blood draw or fingerprint taken at booking. The act of merely provided CHP with access to a source of information. From a practical standpoint, this is chilling. The Supreme Court ruled in 2016 that police officers need a warrant before drawing blood. Okay, that's good. When I was working, we didn't need a warrant. If I arrested you for a felony, it's called a felony blood draw, and I would take you and draw blood. And I took just about every felony I arrested and did a blood draw. It's called a felony blood draw. Used to be legal. I don't know if it still is. And what I would do with that draw is it would be able to say he was or wasn't under the influence when he gave a statement. If he admitted to something, he couldn't say I was under drugs. He couldn't say he wasn't using drugs. I would get a blood. If he was driving, it would give me his blood and drug content in his system. And it would be entered into the felony public database. So if he ever committed a sex crime and they had DNA on a file, or he committed some other crime and his DNA was there, now his fingerprints and DNA were in that system when they checked for criminals, and they would find it. So anytime I arrested somebody for a felony, I did a felony blood draw. And some people may think that was bad or whatever, but it was lawful, and I did it because I thought it protected a lot of people, and sometimes it solved crimes. I'd arrest somebody for a felony that maybe wasn't a big-time rape felony. It was a burglary, or he used a weapon in a crime or something, and I arrest him for this felony, and I do a felony blood draw, and then another case is solved in another state because they matched his DNA. And he was involved in a rape there. Or he was involved in a shooting there and he was injured and they found his blood at the scene, and now they can put him at the scene and make a case on him. So that's why I thought felony blood draws were a good thing. By forcibly gaining access to someone's phone provides more than identity. It's an entire lives. I agree. Again, I don't think cops ought to be able to get in your phone for any reason. Let me retract that. I can't think of a case where a cop should be able to force entry to your phone. I know everybody's going to be, you're a jackboot, you're just supporting cops, you're anti-government. Wait a minute. If I'm searching for a kidnapped kid, and I worked child abduction for 3 years, if I'm searching for a kidnapped kid and I get you and I know you're the guy and I have reason to believe you're the guy and I have reason to believe you have that kid somewhere, I think I should be able to force entry in that phone to find that kid either before it starves, runs out of oxygen, it is locked up, whatever it is. I think in that case, I should be able to force entry into your phone and force you and physically take your thumb and say, you need to open this phone so I can find this kid, because this phone probably has evidence that will help me locate a kid that's in danger right freaking now, and that's an exigency. So I can think of a case where I think we should be able to force phone, but I can't think of many. It would have to be very narrowly construed to where somebody's life is in imminent danger and this may save them. That's the only way I can say force in your phone. Otherwise, your phone, you need to get a freaking warrant. Period. No ifs, ands, buts, or coconuts. Fourth Amendment, Drew, writs, general warrants. General warrants, the British. A general warrant was basically, you could just search anybody. I've talked about these before. So if you have a general warrant, the cops will just walk in your house and go, we're going to look around. But I haven't done anything. We don't need to say you did anything. We can just look around. Exactly what cops do now to your car. It's the same thing. Cops are modern day redcoats, probably worse than the redcoats, because we have idiots running around back to blue all the time. There's no difference. A searching your car on a traffic stop is a general warrant. They're going to say it's exigency, officer safety, there may be a weapon, cars are highly mobile, we may lose. That's all bullshit. If I want to search your car, I can seize it as evidence, I can have it towed to a secure place, and I can go get a warrant. Cops would never do that. It's too much freaking work. Cops are lazy. They don't want to do paperwork. So what do? The courts make it easy. And the idiots make it easy by saying, back to blue. Oh, they have such a tough job. Let's make it easier for them to violate our rights. So now they can search any car, which is a general warrant in my book. But anyway, I digress. General warrants were bad, and the founders knew it was bad, which is why they said, no. Before you search someone's private area, home, person, whatever, you need a warrant with somebody swearing under penalty of perjury that they know something, that this guy's committing crime, has committed crime, or is committing crime, and you need to get a judicial review, a judge to review that before you search. That takes time. That causes lazy-ass cops to work. Most cops don't want to write warrants. 90% of cops never write a search warrant in their entire career. When you hear all these cops talking about, man, I'm a cop and it's tough and it's hard, they don't. 90% of cops never write a warrant in their whole year. There's some cops that never even pull their gun their whole time. They brag about, I've never had to pull my gun. And I'm not saying necessarily that's bad, but I'm just saying if you're working in the areas that I worked, I pull my gun 5-10 times a day, and it's really kind of routine. And there's cops, oh, man, that's bullshit, man. I've been working 5 years. I've pulled my gun once. Well, it depends on what area. It's not a macho thing that I'm somehow super macho because I pulled my gun. I was working with bad people. So it's obvious. But anyway, general warrants, British, coming to your homes. Fourth Amendment requires a search warrant, probable cause signed by a judge. The big thing that a search warrant does is it stops rogue cops. It stops cops that have too much power. I was a cop. When I was a cop, I said we had too much power. To this day, I say cops have too much power. And I said it when I was a cop. And nobody liked it, but it's true. It forces cops to get judicial review. It forces cops to write out and articulate why they want to search instead of, fuck it, I'm a cop, you ain't got no fucking rights, I'll arrest you for freaking resisting and I can search and I don't need a warrant. So fuck you, pesky citizen. That's the problem when you give cops more authority and make it easier for them to prey on good citizens. And now our law enforcement is nothing but a standing army that does nothing but prey on good citizens, and they ignore criminal elements because they're scared or they're pussies or they're afraid. But they don't mind picking on good citizens who are out there trying to make a living, pay their taxes because they're easy and they won't fight back. Anyway, I digress. That's my take on it. You can take it for what it's worth. I'm not cracking on Steve. I think this parole, Steve didn't cover the parolee aspect as much as I thought he should have to make it a little bit more clear. I think this is going to be overruled. I don't think cops are going to be able to force you to open your phone. They shouldn't, but God knows I've been wrong about government, what government can and can't do, and I'm shocked every freaking day at what we're allowing them to do. So, you know what? I could be dead wrong on this, and it may stand. All right, that's my take. Y'all have a good one.